The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Judge Matok. Court officer, please call the case.
Good morning, Madam President. Good morning, Your Honors. This is a situation in Libya in the case of the prosecutor versus Khaled Mohammed Ali Hishri. Case reference ICC 0111-0125. And for the record, we are in open session.
Judge Matok, thank you very much. Good morning and welcome for this third and last day of hearings going to the confirmation hearing against Mr. Hishri. So before we look to the merits, I just want to check that the parties and participants, whether they have any changes in their teams. And perhaps we can start this time with the legal representative of victims. Madame Pellet? Madame Pellet. Thank you, Rona. Good morning. There are no changes for the team of the legal representative of victims. Judge Mottag, thank you very much, Ms. Pellet. For the prosecution, Deputy Prosecutor.
Good morning, Madam President, Your Honours. Appearances are as before. Ms. Lacey is back with us this morning.
Judge Mottag, my thanks, Deputy Prosecutor. The defence?
Thank you very much, Madam President. We have the same team as previous days. Thank you very much.
Judge Mottag. Thank you very much, Counsel Hassan. I note that Mr. Hishri is with us in the courtroom this morning. So we resume this morning with the oral submissions from the defence. Counsel, over to you.
Thank you, Madam President. Thank you very much, your honorable judges. At the beginning of this day, and it is the last day of our oral submissions in this confirmation of charges hearing, and before I go into the merits of the case, I would like to confirm 2 points. The first point is that the agreement that was signed by the Libyan authorities regarding accepting the jurisdiction of the ICC, and that was already signed by the previous Prime Minister of Libya. I would like to say that the version that was given to us was not signed by anybody, and it was not stamped by the official Libyan stamp. Also, it was not published in the official newspaper of the Libyan government as stated in the constitution, which means that this document is not existent and cannot be used. Today, we are going to talk about the context where Khaled al-Hishri was placed and where the charges came from. So, we are going to talk first about the group that the OTP describes as I mean here what the OTP calls as the Rada group. I will start here from where the prosecutor's office began. This means that I will start from the prosecutor's office's application for an arrest warrant. In the application for the issuance of an arrest warrant, the OTP presented a radar group as an armed group, and that it is an outlaw armed group that was controlling a detention compound where crimes are committed. They were trying to create a mental image that will facilitate fabricating all the crimes and all allegations the OTP are trying to convince you with. That's why I would say that the OTP, who were supposed to obtain all the documents from the beginning before submitting an application for an arrest warrant, they used different linguistic terms through the procedures. At the beginning, they used certain terms, but then they corrected and changed these terminology later in the DCC. These three different groups of terms that the OTP used. Well, first, they used the term an armed group. The second was legal entity. And then the third term that they used was a legal entity that acts as an armed group. In the arrest warrant, dated the 31st of July 2025, the OTP used the term armed group. And that was used by 60% or in 60% of the document. And in the same document, they used the term a legal entity by 30%, and the term legal entity operating as an armed group by 10%, which means that it's in general that they're trying to convince the chamber, the court, by 60% of their document that the radar group is an armed group and not a legal entity. In the DCC, the document containing the charges, the OTP changed the terms that they were using. In 66% of the document, they described a radar group as a legal entity, and they used the term armed group in 33% of the document. And in their pre-trial brief, they used it only by 30%. But then they corrected that and they called it a legal entity by 66% of the document. So you can see, Madam President, honorable judges, that the office of the prosecutor was trying to convince you that we are dealing here with an outlaw armed group and not a legal governmental entity. They were trying to establish a fact here. They wanted to say that all the detainees were illegally imprisoned. The result of this is that the position of the OTP was not determined, was not fixed from the beginning of these procedures. They didn't know, is a radar group an armed group? Is it an outlaw armed group? Or is it a legal entity? Then they moved to talk about the prison of Metega. They said or described it as Metega prison, but they didn't say to what entity exactly it was affiliated. And that's why we have brought enough documents today to show to you what is a radar group and what are their competencies, how they were funded, and how they operated. And I would like to inform the distinguished chamber that a radar group is called, or the real name of it is the Deterrence Apparatus for Combating Organized Crime and Terrorism, DACOT. And it was a legitimate apparatus established by decrees issued by the competent authority in Libya. And this name, in its final form, or this entity in its final form, cannot be considered the same entity that was established year before that, whether at the time that it was established or the time of its developing it and progressing its role. This entity has changed in its competencies, in its activities, in its composition, and also in its affiliation to the Libyan authorities. Also, we will speak today to you about the Metega prison and its legal description, and this is in slide number 3. Madam President, this is decision number 36 of 2015 on the establishment of a security unit on the 10th of February 2015 with the name of the Special Deterrence Force, Al-Rada. And this decision is issued by the Tripoli Security Directorate of the Libyan Ministry of Interior. Some of the competencies described in this decree, and we're talking here about the Libyan Ministry of Interior. Containing labor relations and executive regulations, carrying out interventions, raid and riot control operations in accordance with security requirements, providing support and assistance to the police stations and department of the Directorate, deploying patrols within the Directorate's jurisdiction to maintain security and public order. These are some of the competencies of the apparatus. Here, slide number 4. It's decree number 37 of 2015, issued by the Tripoli Security Directorate on 10th of February 2015. And in article number 1, it says that First Lieutenant Abdulrauf Ahmed Salem Kara is hereby assigned as a commander. First Lieutenant is a rank inside the Ministry of Lieutenant. Here we are talking about a civil servant inside the government of Libya and not just a lay person. Not just a person who is working in an outlaw armed group. No, we are talking here about a civil servant in the Ministry of Interior. And here it says this decision enter its force from the date of its issuance, and it's signed by the Director of Tripoli Security, Abdurrahman Al-Arifi Bashir. We move now to slide number 5. We have here a letter from the head of the Office of Administrative Affairs at the Ministry of Interior, addressed to heads of offices and sections, notifying them of Article 36. And it's also signed by the Office of the Director of Security in the Ministry of Interior in the Libyan authorities. Now we move to slide number 6. Decree number 555 of 2018, issued by the Libyan Presidential Council. This is a very important turning point here. We have to stop here for a moment, because by this decree, the Special Deterrence Force, Al-Rada, was dissolved. and a new entity was established, DACOT, Deterrence Apparatus to Combat Organized Crime and Terrorism. And in the Article 1 of this decision, an agency shall hereby be established under the name Organized Crime and Terrorism Deterrence Agency. It shall have an independent legal personality and financial autonomy and shall be affiliated to the Interior Ministry. And on Article 8 of the same decision, the members should be affiliated to the Interior Ministry and should perform their own competencies. And it should be funded as part of the general budget of the state. So here, Madam President, we reach the end of this decree that is issued by the highest authority in Libya, which is the Libyan Presidential Council. After that, decision number 587 was issued, slide number 7. It was on the organization of DACOT, and it was dated the 1st of September 2020, and it was issued also by the Libyan Presidential Council. Let's read article number 1. The Deterrence Agency for Combating Organized Crime and Terrorism shall be reorganized as follows. It shall be renamed and shall have an independent legal personality and independent budget and shall be subordinate to the Presidential Council. While Article 4 reads as, the agency shall have a head who shall be appointed by a decision from the chair of the Presidential Council. And in Article 5, the agency shall have a deputy head who shall be appointed by a decision issued by the chair of the Presidential Council on the basis of a proposal from the head of the agency, and who shall assume all the powers assigned to the head of the agency in the event of his absence. And the most important article here is article number 11. Members of the agency shall be subject to the provisions of Law number 7 of 2012 on the establishment of the General Intelligence Services in Libya with respect to promotions, payroll, financial benefits, rewards and bonuses, and as appropriate to the nature of their work. Here, Madam President, we reach the real description of a Rada group based on the official decisions and decrees by Libya. All of this was not presented to you in their application, the prosecutor's application for an arrest warrant. Let me move now to the decision of the Minister of Justice, and this is slide number 9, and it is decree number 699 of 2017. It is a decree on the establishment of the Metega prison. The legal name of this prison was Tripoli Correction and Rehabilitation Institution. And in article number 1, It says, establishing a main reform and rehabilitation institution under the name Tripoli, located at the Metega Air Base, with a total area of 20,980 square meter. There are two other letters also issued after this letter. One of them was issued by the Minister of Justice and addressed to the head of the Judicial Police and the Director of the Attorney General's Office. And if we move to slide number 11, this is a letter issued by the Attorney General of Libya, Mr. Sakur, to the Special Deterrence Force or Chief and in the decision it says you have to take the appropriate measures in detaining the criminals with the highest level of security. As I said, it is signed by Ahmed Al-Sur, head of the office's investigation division. And here, Madam President, we can see the real description of the Metega prison, which was presented to you by the OTP as a place for massacring people, and a Rada group that was presented to you by the OTP as an outlaw armed group. In fact, a Rada is a legal entity that it was established by the Libyan authorities, whether judicial or police authorities. It had its own composition, and it was working with all the different executive organs of the Libyan authorities. All of the officials working in Arada were civil servants receiving their salaries from the Libyan state. What is called Arada group was never just one single entity during the charged period. It was actually more than one entity together. But what is certain is that all the different forms of this entity, all the different stages of this entity or the formation of this entity were inside the legal, legitimate Libyan state. So, from an analytical reading of the previous decisions and decrees, we can see the extent of correlation between all of these forms and the Libyan police and judicial apparatus, and including the Presidential Council. All of these facts were not presented to you by the OTP. Al-Rada is not an outlaw armed group, and it does not control an illegal detention center where crimes are committed. What was presented in the arrest warrant, Mr. Khalid al-Hishri's arrest warrant, was not as precise as it should be. Such information should have been presented to your esteemed chamber. All of these documents were ignored, were put aside, so that a mental image is drawn, is portrayed about Arada as an illegal armed group, which is outlaw. Al-Rada in all its establishment documents, and in reality, actually, was only working towards law enforcement and the enforcement of security based on instructions coming from the Attorney General and the other Libyan authorities of the Libyan state. To present the Rada group in that way, we are here mixing the legal status. It is very different when we look from a legal perspective to an armed group from looking at an legitimate legal entity. In the criminal law, we cannot mix such status. Elements of crime are determined based on facts and not just on allegations, Madam President. To describe legal security entity as an outlaw armed group in our assessment and the assessment of many Libyans is an insult to the Libyan people and the Libyan state. Thank you, Madam President. From an objective point of view also, and only to test the validity of what the OTP are saying, if we can build, even as just an argument, if we can build on the allegations of the OTP and count the possible number of the so-called Al-Rada members. All the names that were mentioned in all the documents presented by the OTP so far can be counted on one single hand. They mentioned only 4 main names and some other names that are not as important. How many people do you imagine should be working in this place in order to actually control such big place as the Meteke prison? The day before yesterday, the OTP said that the members of the Rada might reach 1,500, but I didn't see the names of 1,500 members in any of the documents. I didn't read really any kind of document that would listed the names of the members of a Rada group. Where did the OTP come with this figure? And who are these 1,500 people?
If the OTP is keen on conducting investigations clearly and strongly to submit it before this court, then they have to identify who are the Rada members exactly, what are their functions, what are the structural functionality and the hierarchy as well, so that we can know whether Khalid al-Hishri was a member in Rada SDF or not. What is proven before this chamber, Madam President, was that Khalid al-Hishri worked as a security officer in the Libyan embassy in Morocco. So this is the only proven document issued by the Libyan state about Mr. al-Hishri. The OTP never mentioned the salary of Khalid al-Hishri in the SDF. they did not tell us who was the supervisor of Khalid al-Hishri based on the paperwork and not based on the sayings of some people. So some people were saying that Usama Nagim was the supervisor of Khalid al-Hishri, but Khalid al-Hishri had superiority over him. So this is not very logical. So we will show you documents of the Libyan state, but this document that we will show you later is confidential. Can we imagine the amounts of money that were spent on the Metega complex? So what is the exact number or amount for the salaries allocated and the expenses for the Metega complex? So can we imagine who is funding this complex and this group and giving them their salaries? Based on the decisions that we have presented, Madam President, all Libyan governments since the establishment of these apparatuses are those that were spending on this group, regardless of its name. Al-Dibeiba's government was also funding this group, and according to the decision, the Minister of Finance issues the decision and the orders to pay the salaries of the members of this group. Because, and briefly, the functions of all the Rada members are governmental functions. Slide 13. To confirm what I had said, Madam President, this is a paper from the OTP documents. So this is Mr. Abdul Hamid Dibeiba and Mr. As-Siddiq As-Sur, Attorney General, and Madam Halima Ibrahim, the Minister of Justice, in addition to Mr. Abdul Rauf Kara in a meeting inside the government office of Libya. And I will read the news as submitted by the prosecution. So the meeting was in the Attorney General's office of Libya, pardon. So this morning in the Attorney General's office, a meeting to follow up on the legal and the living situation of the prisoners in the presence of the Prime Minister Abdul Hamid Dibeiba, the Attorney General As-Siddiq As-Sur, the Minister of Justice Halima Ibrahim, and Bashir Al-Amin, who is from the Ministry of Justice, and Abdul Rauf Kara, the leader of Rada, in addition to Adel Guma from the cabinet, along with the presence of the competent attorney generals. So at the beginning, the Attorney General praised this, the governmental support, and then the leader of the Rada gave a detailed report about the DACOT work. He also talked about the measures they are following in order to continue the investigations and to submit them to the Attorney General. He also talked about the living situation and in the prison. And then the Minister of Justice indicated that all detainees in the Metega prison, I'm quoting here the Minister of Justice, all the prisoners are coming before the court based on the legal procedures, and there are no detainees without any legal measures. So this is what the Minister of Justice said. So can the defense question that Mr. Al-Dibeiba in this meeting was coordinating with Abdul Rauf Kara about anything here? Or can we say that he is a member of the Rada group? So if there's somebody else who would like to take this picture without the news, so you can put any news to the picture. However, this picture submitted by the OTP proves that there is a relationship between the Rada apparatus with the government and with the Prime Minister Abdulhamid Dubeiba himself. So I'm saying that this relationship is protected by law and is not illegal. But saying that a Rada apparatus is unlawful or illegal, or that it was committing crimes, then this is a dangerous error here. And this picture here speaks for itself. I can imagine what any person in this picture would say about it. So if one of these people who are in the picture is accused, then this person would find it easy to say that all those in the picture with them are partners. However, the actual truth is different from what the prosecution submitted. The actual truth is that the SDF Rada is a legal and lawful institution working within the Libyan state. This apparatus follows the executive power in Libya, and it follows the Presidential Council of Libya, and it's the council that gave it all its functions. So what is the relationship of Khalid al-Hishri with leaders of such a level in Libya? Yesterday and the day before, OTP said that Khalid al-Hishri was a leader in Rada apparatus, and he is a fisherman. So I cannot see how he is a fisherman and a leader in the Rada. It's either this or that. But the truth is something else. The truth is what is proven in the paper submitted to this chamber, and this is that Khalid al-Hishri is a security officer working in the Libyan embassy in the Moroccan kingdom, or in the Kingdom of Morocco. Slide 14. This is a very important picture as well, Madam President. So this is Mr. Mohammed Al-Menafi, who is the head of the Libyan Presidential Council, the first executive power in Libya that is recognized by law, and he is the spokesperson of Libya before the UN General Assembly, and this is based on the Security Council resolutions, and also based on all the letters by the Presidential Council. So what do we see in this picture? Who is in this picture? We have the military leadership of the Libyan army. So we have the two main figures in the Libyan army, the head of the intelligence service and others. So we have with them as well Mr. Abdel Raouf Kara, the leader of the Rada. So the highest executive power in the country, would it meet with armed groups without having any link with them? So this is not real. So how can we read this image well? So this says that Mr. Al-Menafi met with security figures from the intelligence and the army, and Abdel Raouf Kara is the representative of one of the security apparatuses. Madam President, esteemed chamber, the office of the prosecutor is bound by respecting the Rome Statute and all standards of proof, all of them without any selection or discrimination, and not just providing any proof or any evidence. The OTP has also found any proof of innocence. However, unfortunately, the OTP did not abide by Article 54A and C. So I will read the text of this article. The Office of the Prosecutor does the following. 1. To prove the truth, in order to establish the facts, extend the scope of the investigation to include all facts and evidence relevant to the assessment of whether there is criminal responsibility under the present statute, and in doing so, investigate both the circumstances of incrimination and acquittal. So, it fully respects the rights of persons arising under this statute. I can say with full confidence that the Office of the Prosecutor did not respect this text, at least up until now or up until what was submitted to the court. So the Office of the Prosecutor did not request any data related to the number of the members of the Rada, what is the budget and its headquarters. It did not request the hierarchical structure of the Rada from the government to see what is the hierarchy and the chain of command in order to identify criminal responsibilities. Despite that, the OTP said that it concluded an agreement with the Prime Minister who pledged to cooperate with the court and provide help. The OTP did not request a proof of salaries from the Ministry of Interior in order to identify the function of each of its members and what they were doing. It did not address the Libyan Attorney General or the Ministry of Justice in order to inquire about the 65 witnesses, whether they had any formal accusations against them or not, or whether there are criminal charges against them or not. So what was submitted is that they were detainees. Why? We don't know. The office did not request the regulations of Libyan prisons to see whether they were applied or not. And what was said about the searches that happened at the entrance of the Mitega prison, I know for sure that there are European countries that conduct searches in the most private areas on prisoners every day, and all the searches are conducted completely and in a worse manner than the manner described by the OTP earlier. So if the OTP had requested the regulations of Libyan prisons, we would have known whether these measures violate the law or not. So the Libyan Ministry of Justice was not asked for a disclosure of whether there were any verdicts issued against any of the witnesses in this case to know whether these witnesses are testifying rightfully or not. The prosecutor has a very high number of investigators with great capabilities, and they have a full building, and the defense only has one room. The question is, couldn't all these capabilities be used in order to also find the proof of acquittal against for Mr. Hishri? We are asking for the implementation of Article 54A and C. So if they had investigation this way, then they wouldn't, the OTP wouldn't have requested a warrant of arrest against Mr. Al-Hishri. And if all the evidence was collected with neutrality, then it would have been proven without any doubt that the Rada is a legal and lawful apparatus established based on government orders. It has a specific structure, and that Khalid al-Hishri was never a leader in the SDF Rada. I will also present to you a sample evidence of the prosecution's error when it comes to the investigation. So please show slide 15 to be shown secretly, with confidentiality. So this is a letter issued by the same entity that gave the court its jurisdiction. So I would like to review paragraph 6 of this letter that says that Mr. Osama al-Masri Najim organizationally and functionally is not a member of the SDF Rada in the first place. So how can he be a leader in it anyway? However, if the OTP is the one that submitted this letter. So the OTP also recognized the agreement of 14/5/2025. So both, if they recognize both these documents, then the OTP has to answer which document is correct. So, which is correct? Is it the documentation that says that Osama Najim is a leader in the SDF Rada, or this document that was submitted by the same entity? So, is he a member of SDF Rada or not? Which document is correct? Both these documents were submitted by the OTP. So this undermines the credibility of the evidence submitted by the OTP. And everything that was said in the testimonies is general, ambiguous, and they were never tested before the court. So all these testimonies are from one side, and we cannot know for sure whether they are correct or not, or whether they had other motivations. Madam President, esteemed chamber, Khalid al-Hishri was never present in a structure of any security apparatus in Libya. He is not a leading member in any group, and there are no evidence that prove otherwise. So we cannot deal with the witness testimonies as a holy book as long as they are not challenged or tested. Because some of them, for example, some of the witnesses might have had promises for enrichment, and this happened before international courts before. And you will see later on that some of the witnesses against Khalid al-Hishri are ISIS members, and this is very possible. Madam President, esteemed chamber, the negligence when it comes to Article 54, paragraphs A and C, and the serious violation of the rights of Mr. Khalid al-Hishri are the things that led to the issuance of an arrest warrant against him. And we are wondering how a person who does not have any specific functions can be a member of a governmental apparatus and appointed by the Attorney General and is supervised by the Ministry of Justice. How can he be a part of a common plan here? So without the prosecutor telling us, according to their documents, from this is what he's doing, so this person has a specific job and belongs to the agency in question, or on a specific date on this job, this grade. So is it logical that a person who was transferred to work as a security officer in the Libyan embassy in the Kingdom of Morocco would have been working or in parallel with the leadership of the state, with the leadership of security apparatuses? So is this logical in one of the wealthiest and most important countries in Africa? So if the OTP wants to enforce only a part of the rule, then their works are incomplete and do not meet the conditions of admission before this court, and the legal works are incomplete in terms of the conditions of full and impartial investigation and deserve to be rejected. Slide 16. Madam President, this is the penultimate slide, and the picture was also submitted by the OTP. This is the Metega prison, and we see the Ministry of Justice and the Office of the Attorney General representatives are visiting the prison. So the image is clear. Khalid al-Hishri is not in any of these pictures. Slide 17. Madam President, this image shows clearly the establishment or the succession of decisions and decrees that established the so-called SDF Rada, or the different agencies said by the OTP that they are one entity. So all these were established based on the governmental decisions, and they were all these decisions were issued by the Libyan state. However, Madam President, what is the difference between this apparatus being established by the Libyan government or an armed group? So, because in our team, we conducted a lengthy dialogue on what difference would it make whether it was a governmental entity or an armed group. So here the criminal context will differ, and the elements of crimes will differ. That is, if the crime was there within the common plan or not, or whether the arrests happened based on lawful decisions or not. So all this affect the presence of the crime or not. But if this apparatus was an armed group, then things would be completely different. The final point in this section is that what the OTP calls as SDF Rada is a Libyan government apparatus established by the Libyan government, and the Libyan government spends on it, and all its affiliates and members are government employees, and it was under the control of the Libyan state at its highest levels. And when the prosecutor calls the Metega prison as a detention center, then this is not correct, because it is an official prison of the Libyan state, and it's called the Tripoli Main Reform and Rehabilitation Center, established by the Libyan Ministry of Justice, and it follows the Libyan Attorney General. And the OTP has not submitted whether the witnesses were being held for legal reasons or not. Thank you, Madam President. I am done with this part of my presentation. I will move now to the second part of my presentation, and I will talk about crimes against humanity.
À ce point.
Judge Martok, thank you, Councillor Hassan. Please continue on this point.
Thank you, Madam President. I was just checking the time. My colleague, Ian Edwards, yesterday talked about what is called crimes, war crimes, and he provided a detailed presentation about it. And now we will talk about the charges related to crimes against humanity. I will be brief and will not take long. So the term crimes against humanity is often used inaccurately to talk about various forms of violence. However, the Rome Statute, as well as the jurisprudence of international criminal justice, set out specific definitions of crimes against humanity. The Rome Statute says that crimes against humanity are acts prohibited, committed in the context of a widespread or systematic attack, which is an implementation or furtherance of the policy of a state or organization, and directed against any group of a civilian population. We understand here that crimes against humanity are based on specific legal elements that must be met. And at this stage of the proceedings, the burden of proof falls on the prosecution in order to convince the court that there are substantial grounds to believe that these elements have been fulfilled and that Mr. Khalid al-Hishri was personally involved in them. And in the contextual elements of crimes against humanity, or the contextual elements of crimes against humanity, are what give this court jurisdiction to hear this case. Otherwise, we would be dealing with ordinary criminal offenses that fall under the scope of the Libyan national jurisdiction. Therefore, the contextual elements of the existence of an attack, the existence of a standing policy, and the directing of such an attack against a civilian population, and the characterization of this attack as being widespread or systematic with a link to the perpetrator must be first established before looking into any individual acts. And the absence of any of these elements completely excludes the possibility of proving that crimes against humanity have happened, and the absence of only one element makes it legally unnecessary to examine the rest. This approach was settled in the decision to confirm the charges in the Burishmana case, along with other cases. And a realistic tracking of the situation in Libya, as well as the nature and activities of the so-called SDF Rada, is an essential element for understanding the legal and factual shortcomings in the prosecution's theory of crimes against humanity. The role played by this apparatus in implementing some of the security and legal measures approved by the Libyan state, especially when it comes to combating drug crimes, theft, and organized crime, this was primarily the execution of judicial orders.
Madam President, in front of you is a slide here showing that a Rada group did not conduct any attacks against the civilian population, and that all that they did was just law enforcement operations that were legitimate and under the supervision of the Attorney General and the Ministry of Justice. We are trying to prove here to your esteemed chamber that there was no attack conducted by this group against the civilians. Your esteemed panel has listened to the story of the prosecution that portrays the members of the Rada group as a group acting according to its own interests without regard to the society to which it belongs. However, this narrative differs strongly if we understand the political, social, and anthropological state of the Libyan reality. So the so-called SDF Rada, as we have explained, is part of the Libyan legal authorities, and its members are Libyans from the same social fabric of the city of Tripoli. So we are trying to focus on three main axes. There were no attack. We're falling within the meaning of the international criminal law that happened against the civilian population. Second slide. It is understood in the international law that the conduct must be criminal and systematic and continuous. It can't be individual incidents. And the purpose of this requirement is to exclude acts that are isolated from the scope of international criminal law. As Judge Janiel Matro has made it clear, the crimes against humanity are not just an accumulation of sporadic criminal acts, but a collective criminal project directed against the civilians with a common goal. And this is not existent in the behavior of a Rada group or the behavior of Khalid al-Hishri. The events that took place between 2014 and 2020 do not reveal by any way the existence of a general behavior directed against the civilian population in or around Tripoli, but rather all that is described are actions taken against persons suspected of committing crimes, whether in cases of flagrant violation of the law or in order to implement orders issued by the competent Libyan judicial authorities. The civilian population was never a direct target of SDF Rada or any other perpetrators, or as the prosecution called them, perpetrators of Metega. Rather, the agency's operations were aimed at carrying out actions against a limited number of individuals suspected of committing crimes in accordance with judicial orders or orders issued by the Libyan public prosecution. So what the OTP is calling attacks were nothing but legal procedures taken against suspected criminals by the Rada group. The law also requires that the civilian population must be the primary target of the attack, not merely accidental victims. This court has affirmed this principle more than once, such as in the cases of Katanga and Hassan. However, the evidence presented by the prosecution does not in any way amount to meet this standard. Therefore, the prosecution is wrongful. They erred when they portrayed a legitimate law enforcement agency and operations as an attack against a civilian population. Adopting such an interpretation would open the door to categorize the activities of law enforcement agencies around the world as international crimes, and this is a threat to legal legitimacy. The Special Court for Sierra Leone in the Fofana and Kondiowa case recognized the genuine and effective efforts to protect civilians, weakened the allegation of an attack directed against them. In this sense, the Rada group operated under the orders of judicial institutions in Tripoli, whereas Article 7 of the Rome Statute stipulates the attack must have been carried out in implementation or in furtherance of the policy of a state or organization. But that is not the case in Tripoli. Not surprisingly, the OTP has not addressed this element or rather addressed it only marginally, because it simply doesn't exist. Al-Rada, SDF, or what is the so-called Mitega perpetrators have never had a policy aimed at attacking or intimidating the residents of Tripoli. If there is a policy, it was a policy aimed at law enforcement and combating crime in the most dangerous areas of the Libyan state, as is the case in any country. Second, the stipulation of the civilian population. In their application for the issuance of an initial arrest warrant, and also in the decision of this chamber, the prosecution and the pre-trial chamber considered that the civilian population were the people or the persons detained in the Mitega prison, who were perceived, at least in part, as opponents of the government of the National Accord or SDF Rada. But this allegation, and without any explanation, was reiterated in the document containing the charges and extended the scope of the civilian population to the entire population of Tripoli and all its regions, including those detained in Mitega prison. The prosecution here is legally obliged to establish elements of crime against humanity for this expanded civilian population, according to the substantial grounds for belief criterion, and this is not existent. They expanded the number of civilians to conclude the large population. And then they limited the acts to the Mitega prison. Well, they need to make their mind. Is it the whole of Tripoli or just Mitega prison? And also, the second pretrial chamber in the Kenyatta case held that the term any group of civilian population means groups that could be distinguished by common characteristics such as the nationality, ethnicity, or other distinguishing characteristics. That is, the group must be relatively stable and identifiable as a self-contained or a self-dependent group. Going back to the origin of this legal text, we find that it originated in relation to a specific religious group in Germany during World War II. The persons arrested by SDF Rada, in accordance with its competencies, stipulated in official resolutions, were people who were committed or suspected of committing crimes such as kidnapping, terrorism, drug trafficking, murder, and theft. The fact that a person is suspected of a crime is not fixed, or a fixed character or an element of his or her own identity, but is a temporary and transient legal status. I will stop here, Madam President, with the crimes against humanity, because, as we said, if this element does not exist, then there is no point in discussing the rest of the elements. And by that, I conclude my submissions today. There will be a concluding remarks at the end of today's session, but we will obviously be under your orders. Thank you.
Thank you very much, Counsel. Thank you very much, Counsel Hassan. Perhaps I can ask my colleagues whether they have any questions. I see none. So, I would like to thank you, Counsel. The Chamber stated in its 28th of April last order that it would only welcome final submissions from the parties if that proved absolutely necessary, for example, to grant a right to response on matters arising only for the first time during this hearing. Any request of that nature from the legal representative of victims?
Madame la Présidente.
Madame Passidi, yes, we do indeed wish to enter such a request. We've heard the defense. As you know, we decided not to put submissions to the merits, but we do have 3 or 4 questions arising out of defence's submissions, including some legal matters, that it would be important for the victims that we put that before your chamber. So we're requesting a maximum of 25 minutes, perhaps shorter, to address ourselves to those final submissions. Thanks very much, Your Honor. Presiding Judge. Thank you very much, Councillor Masidi. The floor is yours.
Madam President, Your Honours, the defense opening statement resembled less a confirmation hearing submission and more a guided tour through 15 years of Libyan history, with Mitiga surfacing only occasionally as a distant landmark amid discussions of NATO air campaigns, UN Security Council resolutions, constitutional amendments, and Mr. Dibaiba's political fate. The underlying strategy, however, was fairly clear: to shift the focus away from the crimes allegedly committed in Mitiga and the victims' suffering toward a broader argument about jurisdiction, political selectivity, and the prosecution's evolving Libya strategy. What made the submission somewhat unusual at the present procedural stage was that most of these jurisdictional arguments had already been extensively addressed in writing and are currently pending before the Chamber. While the defense sought to portray the court's engagement in Libya as politically selective, their submissions largely remained detached from the specific factual and evidentiary allegations currently before this chamber. Allegations the victims recall concerning torture, enslavement, inhuman treatment, persecution, outrages upon personal dignity, murder, rape, and other forms of sexual violence. Turning to the merits of the defense submissions. Much of the presentation focused on procedural unfairness, institutional critique, analogies, and abstract jurisdictional arguments, while the detailed factual allegation concerning the crimes allegedly committed in Mitiga received comparatively little attention. The defense repeated complaints about anonymous witnesses were framed in highly dramatic terms, owing to comparisons to a boxer fighting with one arm behind his back, or a gambler forced to bet only on certain roulette numbers. While these analogies were vivid, they were perhaps less persuasive than intended. Most of these arguments simply relitigate issues already extensively addressed in written submissions and resolved by the Chamber through the existing protective measures framework. As recognized by the defense itself, confirmation proceedings are not trials on the merits, nor do they require final credibility determinations beyond reasonable doubt or the immediate disclosures of every witness identity, particularly where security concerns remain important, as in the case of Libya and Mitiga. At this stage, the Chamber's task is simply to determine whether there are substantial grounds to believe that the crimes charged were committed. Moreover, the defense suggestion that it is almost incapable of responding because witness identities remain protected sits somewhat uneasily alongside the extensive factual submissions it nevertheless advanced concerning detention motives, domestic law enforcement, counter-terrorism operations, migration, ISIS affiliation, and the institutional role and competencies of RADA. The defense cannot simultaneously claim to know too little to respond meaningfully while confidently advancing alternative factual narratives about the rationale for detention practices over a 6-year period. The alibi argument is similarly unconvincing. The defense suggested that the charge period was too broad to permit meaningful alibi notice because Mr. Hishri traveled during the relevant years. Yet the prosecution does not allege that he committed a single, isolated act on an unknown afternoon in a remote location. Rather, the allegation is that he occupied a position of authority within an abusive detention system operating over years. The inability to pinpoint his location to the minute, as counsel suggested, clearly overlooks the fundamental nature of the charges. Turning to the legal arguments, we address two discrete issues. First, the alleged insufficiency of evidence on the armed conflict in Libya at the material time and the charged crime. And two, the exclusion of the crimes of enslavement and persecution in relation to black migrants. In relation to the nexus requirement for war crimes, as recalled by the prosecution on Monday, and in the response to the defense notes filed before the hearing, document 115 in the case record, the core consistent jurisprudence establishes that assessing whether the suspect conduct is sufficiently connected to the armed conflict must be based on multiple factors, such as, and I quote, the fact that the perpetrator is a combatant, the fact that the victim is a non-combatant, the fact that the victim is a member of the opposing party, the fact that the act may be said to serve the ultimate goal of a military campaign, and the fact that the crime is committed as part of or in the context of the perpetrator's official duty. End of quote. The reference, Your Honor, is the appeal judgment in the Ntaganda case, 15 June 2017, document 1962, paragraph 68. A full and comprehensive assessment of the facts of this case, consistent with the appeal chamber judgment, leads to the following conclusion. 1. Mr. Hishri was a founding member of and a senior official in an armed group, the SDF, also known as RADA, which was associated with the GNA. 2. The GNA and the SDF RADA were engaged in a conflict of not an international character against the Libyan National Army. 3. At the time of the commission of the alleged crimes, the SDF RADA had taken control of a Mitiga prison. 4. Mr. Hishri's ability to commit the alleged crimes stemmed directly from the fact that he was in charge of a detention facility which in and of itself was a consequence of the armed conflict. In this regard, in the Said case, which likewise concerns the treatment of detainees in a detention facility, the OCRB, operated by an armed group in power at the time of the charged crimes, in the context of a conflict not of an international character, Pre-Trial Chamber 2, in the decision containing the charges, correctly took into account various relevant factors, including the suspect position of authority, his perception of the detainees, and the broader general context, namely the circumstances leading to Mr. Said being allegedly in charge of a prison and in a position to commit the crimes. On this basis, Pre-Trial Chamber 2 concluded that a number of war crimes had allegedly been committed. Importantly, and it goes, Your Honours, to some of the remarks made by learned colleague this morning, pre-trial Chamber 2 reached this conclusion despite the submissions of Mr. Say's defense, where he was merely maintaining public order and simply discharging police duties. Even more strikingly, pre-trial Chamber 2 considered the evidence brought forward by the prosecution to be illustrative of the occurrence of crimes, and on that basis concluded that the alleged war crimes were committed against all detainees present at the relevant time, including those for whom no specific evidence was adduced. Accordingly, the reasons why individuals ended up in Mitiga prisons are both factually and legally wholly irrelevant to determine whether the suspect conduct was sufficiently connected to the armed conflict. Turning to the submissions regarding black migrants, these were perhaps the most strikingly detached from the evidentiary record corroborated by the victims' accounts. The defense argues first that black migrant detainees did not belong to the same civilian population against whom the alleged attack was directed, and second, that the allegations of enslavement had effectively been rejected at arrest warrant stage. Neither submission withstands closer scrutiny. The victim's account depicts a far more structured and systematic pattern of abuse extending far beyond incidental mistreatment of migrants in detention. Victims consistently describe black migrants as occupying a distinct subordinated position within Mitigan prison, referred to as slaves, deprived of their identity and autonomy, forced into exhausting labor, compelled to participate in abusive practices, and subjected to coercion, sexual violence, humiliation, and the conditions of complete dependency and subjection. The evidence, taken as a whole, points to an organized system of domination and exploitation rather than isolated or opportunistic misconduct. Importantly, the defense submission rests on a legal premise that finds no clear support in Article 7 of the statute. The defense appears to suggest that for the contextual elements of crimes against humanity to be met, every victim of an underlying crime must belong to the same civilian population against whom the attack is principally directed. Yet, Article 7 imposes no such requirement. The chapeau of Article 7 requires that prohibited conduct be committed, I quote, as part of a widespread or systematic attack directed against any civilian population, end of quote, and that the perpetrator possesses knowledge of that attack. The focus of the inquiry is therefore whether the criminal conduct formed part of the attack and bore a sufficient nexus to it. Nothing in the text of the provision requires that every victim of each underlying crime belong to the principal civilian population against whom the attack is directed. Accordingly, the relevant question in the present case is not whether black migrants belonged to the precise civilian subgroup allegedly targeted by RADA, but whether the crimes committed against them form part of the same widespread and or systematic attack. The evidence strongly supports such a conclusion. The crimes against black migrants occurred within the same detention infrastructure, at the same facility, under the authority of the same organizational apparatus, and through the same machinery of coercion and violence, that characterized the treatment of other detainees at Mitiga. Victims describe overlapping perpetrators, methods of abuse, patterns of detention, and systems of control. These factors strongly indicate that the alleged crimes against black migrants were not detached or incidental acts, but formed part of the same broader attack and were committed with knowledge thereof. This understanding is consistent with the court's jurisprudence. For instance, in the Said case again, as with war crimes, pre-trial chamber 2 found that the crimes against humanity of imprisonment or other severe deprivation of physical liberty, torture, and other inhuman acts were committed against all the detainees of the OCRB detention facility without engaging in any way with evaluation of whether the victims belonged to the group targeted by the attack. While the Chamber did not expressly treat membership in a particular targeted subgroup as an independent legal criterion, its reasoning focused on whether the alleged conduct formed part of the attack and treated detainees subjected to the relevant conduct as potential victims of crimes against humanity. Nothing in that reasoning suggests that each victim was required to independently establish membership in the principal civilian population against whom the attack was directed. Consistent with its finding on war crimes, pre-trial chamber to consider the prosecution evidence to be again illustrative of the occurrence of crimes and concluded that these alleged crimes against humanity were committed against all detainees present at the relevant time, including those for whom no specific evidence was adduced. The same reasoning, Your Honors, applies here. Even assuming arguendo that black migrants constituted a distinct and particularly vulnerable group within Mitiga, this would not place them outside the protective scope of Article 7, where the crimes alleged against them, including enslavement, imprisonment, torture, sexual violence, persecution, and other inhuman acts, form part of the same widespread or systematic attack. This conclusion is reinforced by Article 7(1)(c) of the statute, which defines the crime of enslavement through the exercise of powers attaching to the right of ownership over a person. The provision contains no language limiting its application to victims belonging to the same civilian population that was being attacked. The absence of such language strongly suggests that no such restriction was intended. A plain reading of Article 7 of the statute, interpreted in accordance with its ordinary meaning, context, and its object and purpose, is unambiguous. Any civilian population may be the target of an attack under said provision, and there exists no requirement that the victim must be part of that population. Should any doubt remain, recourse to supplementary means of interpretation, such as the preparatory works, confirms that the drafters of the statute intended to adopt a broad and inclusive approach regarding the scope of victims of crimes against humanity, and deliberately chose to not impose limitation based on group membership or status. The defense further argues that black migrants were detained for reasons unrelated to opposition to RADA or its ideology. But this formulation, Your Honors, oversimplifies the prosecution theory. The allegation is not merely that migrants held anti-RADA political views. Rather, the evidence shows that black migrants were targeted precisely because of their vulnerability, race, nationality, precarious legal status, and exploited as a source of forced labor for the benefit of Rada. Systems of domination and exploitation do not require victims to be political opponents in the conventional sense in order to fall within the ambit of crimes against humanity. Moreover, the evidence also reflects particularly severe and cruel treatment of migrants by the suspect, consistent with a specific persecutorial intent directed towards this especially vulnerable segment of persons subjected to the attack. The defense presentation ultimately left a conspicuous void. Meaningful engagement with lived reality described by victims and substantiated throughout the evidentiary record. Accounts of overcrowding, starvation, disappearances, torture, sexual violence, forced labor, coercion, humiliation, ideological indoctrination, and the pervasive climate of fear alleged sustained in Mythica for years received only cursory attention. Instead, the defense devoted substantial time to contesting labels, jurisdictional theories, and procedural frameworks. Far less effort was given to the central factual question of this case. Why? Dozens of victims from diverse backgrounds recount strikingly similar patterns of abuse within the same detention system during the same period of time under the authority of the same armed group. That disproportion, the emphasis on abstractions over allegations, is itself revealing. Madam President, Your Honors, victims submit that the evidence presented by the prosecution meets the evidentiary standard of substantial grounds to believe that the suspect committed each of the crimes charged and that Mr. El-Hishri bears individual criminal responsibility under Article 25 of the statute. The confirmation of all charges is not only legally warranted, it is essential to the integrity of international criminal justice. On behalf of the victims, we respectfully ask this chamber to affirm that their suffering matters, that their rights matters, and that the rule of law extends even to the most powerful, by confirming all the charges against Mr. El-Hishri and committing him to trial. Thank you, Your Honor.
Judge Marshall, thank you very much. Councillor Masida. Now, we need to know how to move forward because we should finish this session at midday. So let me call upon the Deputy Prosecutor. Do you have any comments, observations at this juncture, or any final submissions that you may wish to put under Article 122, Paragraph 8? And then how long would you wish to do that for, please?
Thank you, Madam President, Your Honours. I will be just a few minutes. The prosecution does not consider that there is anything specific that we wish to respond to the defence in relation to these proceedings. We do wish to say, however, that we're very aware that Your Honour set a timeline for response in relation to the status and relevance of the Article 12.3 declaration, and we will be making submissions in relation to that. But for the moment, we rely on the DCC, the pre-confirmation brief, our written submissions to the defence observations, and I refer to the prosecution filing 115, and our submissions during this hearing to support our case. And we do note that Your Honours held in the confirmation hearing in the case of Duterte, specifically Decision 417, Paragraph 26, that the purpose and scope of the confirmation hearing is limited to ensuring that the charges go beyond mere theory or suspicion. and the prosecution submits that the evidence on which we rely more than adequately satisfies this test. Indeed, our submission is that the evidence is overwhelmingly in support of that threshold. And we have nothing further to say. Thank you, Madam President.
Judge Matok. Thank you, Deputy Prosecutor Ms. Khan. So, those are your final submissions. Have I got that right? Yes? My thank you. Now, I turn to the defense. The time up to midday, is that enough for you for putting your final submissions?
Yes, Madam President. I will only need 5 minutes, 5 minutes for myself and 5 minutes for my colleague Ian.
Judge Matok. Very well, thank you. So I understand that Mr. Edwards will begin first. So, Mr. Edwards, you have the floor.
Thank you very much, Your Honours. I really only need about 30 seconds. I listened carefully to the submissions of counsel for the OPCV, waiting to hear if anything of relevance was said, anything of real pertinence that demands a response was said, and there was nothing. The submissions were a predictable regurgitation of the prosecution's case, peppered with some emotional language about the conditions in Mitiga, but they don't require a response from the defense at all. The only thing I would say, however, relates to the submissions made about enslavement in particular, and those charges of crimes against humanity insofar as they concern that category of complainants that the prosecution called the black migrants. All I would do is respectfully invite my learned friend to carefully read Your Honour's well-structured and well-formulated decision on the arrest warrant, because Your Honour's reasoning in that decision is very clear, and a careful reading of it will inform my learned friend of why you said what you did in respect of enslavement. That's all. Thank you.
Judge Matok, my thank you. Thank you, Mr. Edwards. Mr. Hassan, you now have the floor. This is your last submission, as I understand.
Thank you, Madam President, the Honourable Chamber. Excuse me. The defense would like to ask the Chamber not to adopt or confirm any of the charges directed towards Mr. Khalid al-Hishri. We would like you to take into consideration all our written submissions, especially the brief of 30/4/2026. It is true that we submitted about the lack of jurisdiction of the court, that there's no competence for the court. However, we would like to say that international justice institutions cannot be a means to take some political measures against others or change regimes. Justice is far more noble than being a tool in the hands of a corrupt dictator to discipline national leaders, or a tool or means for these leaders to stay in power. We fought for the establishment of the International Criminal Court, and we supported it, and we still support it in the face of the intimidation and dwarfing campaigns, and making it a tool that can be unlawful. Madam President, esteemed chambers, This court should not be reserved for Khalid al-Hishri and whoever who is in his place. These seats here are dedicated for the killers of children and people, children who are being killed by planes and drones, and their cities and homes are being destroyed. The defense team of Mr. al-Hishri, as you can see, is composed of men and women from different nationalities, different religions, that were chosen by him based on his free will. And there is no bigger proof of his respect to diversity and tolerance, because he knows he is the one who chose these 8 members of this team. So this is a proof of the errors present in the prosecution's submissions. So it will not be fair for Khalid al-Hishri to wait for years for an acquittal decision, and now the decisions might be based on unchallenged or untested evidence. Honorable judges, in our Arab culture we say that the judges are the hand of God on earth. And I salute you for this. And at the end, I would like to extend my respect to this chamber. And I would like to thank also all the officers, the court officers and the interpreters and all the members of the court. And this is the end of my submissions.
Thank you very much, Counsel Hassan. We have reached the end of our hearing. Under the legal provisions that I mentioned at the outset of this hearing, the Chamber will now withdraw to deliberate and, of course, has to rule on the jurisdictional challenge raised by the defence and upon which filings will be received in the next few weeks. Subsequent to that, depending on that decision, on the court's jurisdiction, and in the prescribed time, namely 60 days, the Chamber shall hand down its decision on the charges entered against Mr. al-Hishri. I'd like to also thank the parties and participants, particularly for efforts made to ensure that these hearings are made in open session. I'd also like to particularly draw attention to the rigour of our interpreters, court reporters and all staff members who have helped us over these 3 days. Court is adjourned.
All rise, veuillez vous lever.